have a short period of time. Judiciary meets in here at 9 a.m., so we don't have a lot of time. We're here to consider House Study Bill 539. I'm Representative Holt. I'm the chair. Representative Shipley's joining me. Representative Jacoby has not yet arrived. Hopefully he will shortly, but we do need to get moving because, like I said, we have Judiciary in here in just a few minutes. If there's someone who would like to speak for or against the bill or just share concerns, please come up. I'm going to give you about a minute or two because we're going to run out of time. So, because we need to wrap this up by 8:55. So go ahead.
Thank you, Representative Holt. Caroline Jensen, Iowa Board of Regents. We just have concerns of it's going to establish a new due process for professors, staff, faculty, staff, and students, which would be different than any other state employee process. It also changes the standards from preponderance of, so more than likely, to clear and convincing standard to deal with disciplinary. I think it will make it difficult for the universities to take any disciplinary action against bad actors within the system.
Thank you. Someone else. Go ahead, sir. Go ahead.
Lisa Davis Cook with the Iowa Association for Justice. We are registered as undecided on this bill, and I'm still getting comments back from our folks on this draft. But in the past, I want to share with you some of the things that I've been told by our members who have dealt with this. They have said that routinely those who are accused are denied meaningful due process in these actions. And the current approach places the entire burden on the student to fight back from the allegation. Administrative discretion frequently goes unchecked, and students are left with few options to challenge these deeply consequential decisions. So we welcome some sort of process for these students because we think they're not necessarily always getting it at this point, and so but it also needs some meaningful enforcement mechanisms to ensure that it's being followed when it is implemented. So those are our thoughts. I'm going to get more comments back from our members on this, and I will be sure to share them with the subcommittee.
Thank you. Go ahead, sir.
Great. So good morning, representatives. My name is Michael Hurley. I'm with the Foundation for Individual Rights and Expression, or FIRE. We're a nonprofit that works on campus free speech and campus due process issues. I'll be brief since we're short on time here. We are broadly supportive of HSB 539 because it would markedly improve fairness in campus disciplinary proceedings, providing several vital protections that are often lacking. However, there are several gaps in the bill that may allow universities to skirt its requirements or work around it. And I just want to highlight a few of those today. First, HSB 539 would benefit from a provision that explicitly bars conflicts of interest. Without that prohibition, schools often follow what we call the single investigator model, where one person fills several roles. It's akin to an individual serving as both defense attorney and judge, or prosecutor and judge. So we recommend adding an explicit provision to address that. Additionally, HSB 539 provides a right to counsel, which is very helpful and important, but we suggest adding language to ensure that it protects the right to active assistance of counsel. Oftentimes what we see is schools will narrowly interpret those provisions in order to, they'll allow the attorney to be there, but not to actually participate. Third, we think HSB 539, as was mentioned, would benefit from a clear right to appeal so that abuses and mistakes can be corrected. And then last, we're concerned about the exemption at the start of HSB 539 that allows schools to exempt themselves when necessary to serve a significant institutional interest. In our experience, schools interpret due process requirements very narrowly, so we expect that in this case they would give significant institutional interest a very broad meaning, and so we would suggest either removing that or narrowing it to specified circumstances. And since we're short on time, I'll leave it there. But
just to clarify, the last week you talked about lines 15 through 17 on page 1?
I believe so, yes. The part that allows them to, if they put their exemption in writing and everything, then yes, that's our point of concern.
Thank you for your input. I'm sorry, but everything you said to correct the bill is only 38 lines.
So everything you've done corrected is actually rewriting the whole bill. So I'm confused by your support and then your rewrite. So I find that interesting also that you mentioned due process and an attorney. I think that's very important. Anytime, and I'll say this politely to the group right now, I've been here 22 years. This is the worst written bill I've ever seen. It's the worst written, whether it's by intent or trying to define intent. When we're talking due process in the 5th and 14th Amendment, I think we have to be very explicit. In fact, I think it'd be simpler just to post the 5th and 14th Amendment on the websites of each school. So, and then my other question to you, and you get back to us in the meantime, are you having the same strength or support of due process for foreign students too? And also, will this support for the bill expand over to the private colleges that accept the Iowa tuition grant? Because I've looked at those, I've looked at a number of websites, including Dordt College, and I was rather impressed with Dordt College because they're very much appreciative of civil rights and very appreciative of Title IX. And well, I'm a strong supporter of both. I'm just surprised that maybe some colleges are using that to recruit students, and then we're penalizing the regent schools for doing the same thing. So any information you can provide after today, and I know we're in a hurry, but this is a bill that could really be hurried too much. But thank you.
Absolutely. We would be more than happy to follow up with you after this meeting. Regarding our support for the bill, alongside our suggestions, like I said at the outset, we do support this bill because we think it provides a lot of really important protections that are often missing. What we see is that when schools are required by the current Title IX regulations, for example, to provide these protections like a presumption of innocence, they do so. I think in our last study, it was something like 95% of schools that we looked at did have that in the Title IX context. But outside the Title IX context, I believe it was 60% did not have anything like that. And so that's the issue here. There's a significant gap between the protections the students get in Title IX context versus what they get in other contexts. And despite the fact that courts have held that the Constitution through the 5th and 14th Amendments does require schools to give students due process when they face serious disciplinary consequences, schools often flout that, and what ends up happening is they only change their policies after they go through a lawsuit. And Dordt College is actually maybe an example of this. I know a few years ago, they were actually sued by a student for violation of due process. They're a private university, but common law due process applied there, and the court explained that's the same substantively as constitutional due process, and Dordt had violated that, may have violated that.
But we can catch up on this afterwards. Thank you.
Okay, excuse
Sorry.
me. Well, we're running out of time, and this
Apologies.
is not a debate. This is a subcommittee. Okay, thank you for coming. I appreciate it very much. We will take these comments under advisement, and we'll determine what we're going to do as we move forward today. Thank you all for coming.
Thank you.